Good afternoon, everyone, and thank you for joining us. My name is Daniel Zan, and I'm an articling student at DeRusha Law Firm, and I'll be the moderator of the session. The speakers today are Golan Yaran and Syed Kabir. They are both lawyers here at DeRusha Law Firm with more than 20 years of experience, and they both have experience practicing law in multiple jurisdictions. They are first going to cover a variety of topics focused on changing child and spousal support to a fair and affordable number. Once they're finished with the topics, we will proceed to answer any questions that you may have. If you do have any questions, please make sure you write them down in the chat and type them and send them to me. The chat option should be on your screen. Again, make sure you type your questions there and send them to me, and I'll make sure to present them to our speakers. Please note that this is just a general information session and nothing mentioned should be taken as legal advice. Golan, can you start us off with our first topic, which is basic child support, who qualifies, for how long, and how much?
Yes, certainly. Thank you, Daniel, and good afternoon to those who attend this webinar. Um, as to the topic of basic child support, uh, normally this is governed by the child support guidelines, and it means that any child of parents who are separated is a dependent is entitled to child support. The idea is that the child support is streamlined in such a way that the governing bodies have done a lot of research to find out what would be the appropriate amount, and they came up with a table that sets out specifically what is the amount that is payable to the number of children in the care of the parent, and corresponding to the income of the parent who does not have the primary care given role for the children. So that is in general, the idea is that one can look up the table amount, and that would give you the basic child support amount that is payable for the number of children in the care of the other parent. That is a very general statement regarding the idea of child support. Anything else you want to add, Syed, or we can move on to the...
Yeah, I think, thank you, first of all, everyone, for joining us today. Thank you, Daniel. Thank you, Golan. Just to also add on to what Golan was saying, that in terms of the eligibility or qualification, so child support is actually a mandatory payment that is under the law. And in terms of qualification, the person who's having the child or the children for 60% or more of the time will be entitled to get payment of child support. And if there is like an equal shared parenting regime or shared parenting situation, then there is a different calculation that we do based on the guidelines. So yeah, so that is something that I just wanted to mention. And otherwise, yeah, Golan, you have covered it mostly.
Syed, can you talk about child support now and add-ons beyond the basic support? What qualifies and how do you determine how much?
Yeah, so thank you, Daniel, for that question. So basically, in terms of child support, as Golan was mentioning, that it is determined based on the child support guidelines. The child support guidelines also has a specific section, which is section 7 of the child support guidelines, which talks about special or extraordinary expenses. So this is an add-on to child support. So while the child support payments is based on the guideline amount as to the income of the payer, in terms of section 7 expenses, the law is that it will be proportionate based on the party's income. So based on the party's income, so if a parent has an income of $75,000, the other parent has $25,000, so they would be contributing towards the section 7 or the additional and extraordinary expenses in terms of the percentage of their income proportionate to their income. The only other thing that I wanted to mention is that in terms of the Section 7 expenses, these expenses are supposed to be discussed between the parties, the parents, and then they decide, whether they will be spent or not. There are some expenses like daycare expenses, post-secondary expenses. These are laid in the law that, these are deemed to be Section 7 expenses. But however, in terms of the income of the parties, it can vary as to whether a particular amount or a particular expense is a section that qualifies under law or should be payable for that particular, child. So we all often face situations where we go to court and then only Section 7 is an issue as to whether, this was a Section 7 under the law or based on the situation of the parties. So yeah, that is how it is calculated in proportion to their income. And as I said, that in some situations it also happens that the parties decide, what, we have different incomes, but we are going to agree to equally share the expenses. So it is up to the parties in that situation if they want to come to an agreement of that sort. But the law basically says it's proportionate to their incomes. Is there anything else that you want to add, Golan, to that?
Uh, Perhaps just for the audience to understand that the idea of extracurricular activities or extraordinary expenses um, have been determined over the course of the past several years. Um, a different type of expenses have come up, and the court had to determine whether or not that was extraordinary. The idea is that you have to look at the family, a total income, what was customary, and what would be considered as something well and beyond what is the family was accustomed to. So there are expenses that are by now are given and are very clear that these are adds-on, such as a medical or educational expenses that are needed. But you might find that some activities that would be well and beyond what this family would have been able to afford even on their household income would not be appropriate. So it could be a very expensive type of extreme sport or a racing or anything of that sort that may be um, well beyond the ability of the parents to support in any event. So there is jurisprudence regarding this that is a court made decisions ad hoc, meaning as to the very specific activity that need to be determined from time to time. But most times we're able to agree what is and what is not is available to children in the household.
Yes, exactly, Golan. I mean, you have made it right on the point, because I had once a client who was a CEO of a company, and for his situation, horse riding, which was like $1,200 a month expense, was deemed to be a Section 7. But I'm sure that, a couple or a party that has an income of say 100,000 or less, that would not be deemed to be a Section 7 expense. So it's situation specific. But of course, there is case law which supports, what should be and what should not be a Section 7 expense.
Golan, can you talk to us now about spousal support? Who qualifies, for how long, and how much?
Yeah, so the topic of spousal support, just in general terms, we're talking about the obligation, both moral and legal obligation of spouses to support each other. And that support obligation may be based on actual need when the parties separate. It could be based on what is referred to as a compensatory basis, meaning we're looking at the roles that each spouse has taken over the course of the marriage, uh, their advancement in their career, the roles taken with respect to the children, if somebody was advantaged or economically disadvantaged as a result. All of these factors coming into play, and a mostly is the length of the marriage um, comes into a play, and we have to determine whether you have passed the first threshold of entitlement, meaning the first test that the court has designed is figure out whether the other party is entitled to spousal support. It's not a given, it's not a deemed situation, but the longer the marriage, the more likely that the entitlement is being made out as such. The next thing that we're looking at is the disparity in income, the ability of the spouses to earn income, um, to be out there in the workforce and support themselves. So we're looking at their ability to be self-sufficient and not need the other parent to support them. Um, we have to look at circumstances that may include disabilities. They may include a inability to join the workforce because of lack of education, skills, and anything that may be needed these days to generate income beyond the minimum wage. So all of these factors comes in. So we cannot just say this is the amount, but we have a general guidelines. We use it as a general idea of a range of what could be an appropriate spousal support amount once we figure out all these factors that I mentioned, and essentially the length of the marriage, the disparity in the income, and the availability of financial resources to the parties. But again, we have to take into account other circumstances that are not included in this straight calculation that we lawyers are using in terms of software, and there are other factors that may play in the increase or decrease from the range that is available, and that is the guidelines of spousal support. Anything else on that side?
No, I think you have covered it all. So you have basically stated what the spousal support advisory guidelines actually does, and then you have uh, you have covered it all.
Daniel, maybe we can move on to the next topic here. Or?
Yeah, Syed, can you talk to us now about ongoing or lump sum spousal support?
Yes, thank you, Daniel, for that question. So basically, on that topic, spousal support, when we do the calculation, and then when we look at the entire circumstances as to the length of marriage, as Golan was mentioning, the age of the parties on the date of separation, the income of the parties, all these things we take into consideration. We do the calculations, and then there are two ways of calculating this type of amount or making this payment. So one is an ongoing spousal support. So the guidelines also tells us when we do the calculation as to the duration of the period for which the spousal support would be payable. It can also be paid in a lump sum amount. So in terms of ongoing payments, it can be monthly, it can be quarterly, it can be bi-weekly. It is depending on the agreement of the parties, but usually, when it is ongoing, it is done on a monthly basis. It can also be done by a lump sum. So basically it can be done, I'm going to pay you this amount as one lump sum, and then there will be no further spousal support payable by one party to the other. And then, the parties release each other from making any spousal support payments. The only thing that needs to be understood here is that if it is a lump sum payment, then no tax is payable on the amount by the payer or the receiver. But if it is a monthly amount payable on a periodic basis, then it is tax deductible by the payer and tax payable by the recipient. So he or she, whoever is receiving the amount, has to declare in their income tax returns the following year that this is the amount they received because it is deemed to be an income by the Canada Revenue Agency. So sometimes that is that is a situation where people sometimes go for a lump sum payment. The other thing that also happens is, suppose a person has a certain amount of income, say $100,000, $150,000 income per year, and based on that, the spousal support is calculated. Later on, if he or she is laid off, who's the payer, the income can go down. And then in that case, they can say that, this was a situation at that time, but my income has gone down. So I want to, vary or change the amount. So that can also affect, and that is something that the court will, review. And then the court would decide whether there should be, a lesser amount that is payable. So those are situations where also lump sum payment may be something that, that person who's receiving it would consider taking. So this is basically the ongoing and the lump sum spousal support. Is there anything that you want to add to that, Golan? Golan, you're muted.
Perhaps just to add the significant difference between the child support and spousal support um, has a different tax consequence, and that the parties have to realize when we come to determine the amounts and the duration, and whether it's going to be monthly or by way of a lump sum. The idea is that spousal support is deductible to the payor when child support is an after-tax amount, meaning that nobody gets to claim it on their taxes as a deduction or as or as an income. That's a major difference between these two concepts of support. Daniel, if we can move on to the next topic.
So Golan, can you talk to us now about once child support or spousal support has been determined, what allows for a change, and what's the difference between going to court or doing mediation?
Yeah, so this topic is actually very relevant these days in a situation where many people do experience a significant change in their income source, whether they've been laid off or a situation that are material change in circumstance, as the legislation speaks about that as a specific idea of the grounds for a change. So material change in circumstances, such as what's happening these days, when people are laid off because of the pandemic or because of any restructuring that may occur in a company, and that the payor is in a situation where is unable to maintain the ongoing payment, or similarly, where a recipient of support suffer, or in the alternative, increases their income if, for whatever reason, whether it's an advancement in the employment or being able to be self-supporting because of marriage or other situation, that may qualify for a material change in circumstance that normally would result in a change in the amounts that is being paid or the duration that one would have to pay to the other. The idea is to try to avoid the costly events of going to court for that matter, and we are strongly recommending that there would be communication between the parties through counsel and by way of mediation to try and resolve it in the best economical way possible. So mediation is always a recommended route to try and work out the numbers, to review the circumstances, and come up with a solution without going through the court process that is very timid and expensive.
Yes, just to add to what Golan was saying, also it needs to be understood that, suppose parties do an agreement, say now, and then, within 2 months or 3 months, they have been laid off. Sometimes that might not be seen as material by the judges. So it has to be something like, for lengthier duration to show that actually my income has fallen down. So it has to be material change, not just a change in circumstances. So if the husband was having, say, $80,000 income, the wife was having 50,000, and suddenly the wife is earning 55,000, that might not be deemed to be a material change in circumstances. So there, for a judge to actually review the situation and say that, okay, now there's a situation which demands a change in the payment amount, it has to be material. And the case law has been very consistent on that. And also, we have often seen agreements that have been executed with the parties that, if either of the spouses remarry, there can be a review, automatic review at that time. So there can be circumstances that can be also agreed upon in an agreement where a review would be warranted later on in terms of the circumstances.
Thank you, guys. We're now going to answer any questions that you have. I want to thank those of you who have already sent us your question. If you have not sent us your question yet, it's not too late. You can use the chat option on your screen and send me any questions that you have. Sayed, the first question I have here is, I have a support order to pay a lot of child and spousal support, but my position as a pilot on a commercial plane is on hold, and I've been forced to take a layoff and apply for Canadian emergency funds. I would ordinarily earn over $100,000 a year, but now I am living on $2,000 a month. How can I change my support?
Yes, so I think this is something related to the last topic that we were discussing about, you were saying that, there is a court order, and then you're being paid, you're paying spousal support and child support, but your income has suddenly fallen down. So this is a situation where you want to probably negotiate with the other side, saying that, okay, my situation has changed, I have lost my job, and this was a situation, this pandemic, that nobody foresaw, or nobody was prepared for this. So the best way to to deal with this situation is to negotiate with the other side and come to an agreement. Okay, you know what, for these months, when my income is low, I will be paying you a lesser amount. uh, or if the parties cannot actually negotiate and come to an agreement, then you can also discuss it by way of a mediation. A mediator can actually suggest what is the way forward. But what I have seen in this situation, or when people are in this type of situation where they're being laid off, the other parties are reasonable, because as we say, you cannot get blood out of stone. So they should be considerate, and then there is an agreement that can be done, and later on, if your income increases, and or if next year when your income is calculated, then the amount can be revised or readjusted based on your actual income. But and in case the situation is such that negotiation does not work, or even a mediation does not work, then you might have to go to court, which is the least preferred option. But then you might have to go to court and bring an urgency to the court, saying that okay, this is a situation I have lost, and it's been consistent for some time. So I want to review the amount of child support that is to be paid. But the courts have encouraged all of us and the lawyers to negotiate, to be reasonable, the parties to be reasonable in this unprecedented situation that we are all in now. Gulan, you want to add anything to that?
No, it's very much generally covered. We can move on to the next question. Daniel?
Cool. And this other question I've received is that my spouse and I have separated. Husband works in construction, and he's telling me that he has to pay child support based on his income tax returns, but I know he gets cash on the side that he's not putting on the income tax returns. So what can I do?
So this touches the issue of the determination of one's income. Normally, the starting point is the reporting a income on one's tax return, but it's not the determinative issue. That means that some people are self-employed and others may be a T4 employees, which is easier to determine a income. But when it comes to self-employed or other people that may be not reporting their full income properly, uh, the bottom line is that the court has to be convinced on the evidence that they should be considering a different amount than that is being alleged by the paying spouse. That means that the evidence have to be gathered in such a way that convinces a judge that this person may have other sources of income that is not properly being considered in his tax return. The judge have the ability to what we refer to as imputation of income, meaning we can consider a certain amount that the spouse is making. It could be based on lifestyle, it could be based on certain expenses that are being deducted but are not really business deduction. So some things may be good enough for CRA, but the family law judge may be able, may disregard them and attribute them as income to the self-employed spouse. So there are circumstances that are changing the reported or the basis for the income that the support would be based on.
Yes, just to add to what Golan was saying, Daniel, is that a person can allege, the other spouse is making more income, but Golan has, as Golan has pointed out, it's about proof in a court of law. So there has to be evidence. There has to be, those type of, supporting materials to show that he has such an income. And also, if there is a business that's going on, there might be a requirement of, evaluation of a business to gather what he was earning. So at the end of the day, in a court of law, everything is about proof, and then the court will look at all the situation, and then, if necessary, will impute an income, as Golan was mentioning.
The next question that we've received is that both my husband and I are police officers. We make good incomes. He says that he will pay basic child support according to the guidelines, but argues that all activities of the children are included, such as hockey and gymnastics. Is that true?
Yeah, so as we were discussing before, there are two parts. One is a child support, one is a Section 7 expenses, which is Section 7 of the child support guidelines, which relates to special and extraordinary expenses. So this is an add-on expense on top of the child support amount. And as I was mentioning before, that these expenses like hockey, gymnastics, piano, whatever people, children are involved in, it has to be considered whether these are Section 7 expenses in these circumstances. We review the case law, we review the income of the parties, and then these expenses are proportionate to the parties' income, both parties' income. So if in this situation, if both are police officers, it will be, and we would need to review actually what are the incomes. If it is like similar or same amount of income, say 80,000, 90,000, or 100,000, whatever the income is, it can be a situation where each parties will share the expenses on a 50-50 basis or 55-45 basis based on their income. But to come back to the question, child support is not covering those special expenses. So that would be an additional obligation as per the law. So Section 7 expenses has to be paid based on the parties' proportionate income. And if the parties cannot negotiate, they can try to mediate. If they cannot mediate, then probably this would be leading to a litigation, and the judge will have to decide what is the amount that needs to be paid by the parties in terms of the Section 7 expenses.
The next question we received is, our house is being sold, and I think my husband is moving back to India. How will I collect spousal support from him if he moves back to India?
Golan, you want to answer that?
Yes. So this scenario is really concerning the ability to collect when somebody is out of the country. Now, some countries may be having a mutual agreement with the authorities that is under the UN conventions, and they may be supporting each other when it comes to enforcing spousal support orders. But in this scenario, I think that it would be probably more efficient to ensure that the house that's being sold may be used as security for that spousal support obligation. So a judge may be able to order that the portion that belongs to the spouse who is about to depart from the country will not be released to that party and will be held in trust or released to the spouse who's owed a spousal support. That could secure the payments. It depends on the amount or the share that is available. And that's probably the best route that one should be looking at, and that is security for those payments prior to the departure of the spouse to a country that may not have an enforceable or enforcement agreement with Canada.
Yeah, I mean, exactly, Golan. So basically, in this situation, Daniel, as Golan was mentioning, probably a good idea would be if there is a possibility that the house is sold, and then depending on the amount of equity, maybe a lump sum amount is something that might be negotiated, so that if there is a fear that this person leaves the country and goes back to another country, and there is a question of whether any amount would be payable if it is periodic or ongoing, then probably the best way might be lump sum in this situation.
The next question we have is, the Family Responsibility Office sent me a letter that they were going to take my driver's license away because I'm behind on support payments. I disregarded their letter. Now I'm wondering if I should do anything.
Okay, Daniel, thank you for the question. So basically, in terms of FRO, so they have a lot of authorities. They do have the authority to take driver's license away. They can garnish wages. They even have the authority to put somebody in prison through the court. So they have a lot of authorities. So none of these letters that come from FRO should be ignored or disregarded. Because the authority has been given to them. The courts and the judiciary in Canada and the government sees these support payments as a very onerous obligation, and people should comply with the court order, because FRO only acts when there's a court order, because they are an enforcement authority. Now, in terms of your situation where you have this situation where you are behind in payments, and they are saying that you have to come back, pay, or otherwise they will take your driver's license away. So the options that you have, actually, you can talk to the FRO and then come to a schedule of payments, in terms of maybe you have to pay an additional payment on a monthly basis, or however you negotiate with them. The other way is to, if they are not listening to you, or if they are not agreeable to you know um, um, withdraw or not to proceed to taking your driver's license away, you have an option of going to the court to ask for a refraining order from a judge. So refraining FRO from taking your driver's license away. One of the grounds that you might have, that you might be working and you need your vehicle to drive to work. So if you don't earn any income, how would you be able to even pay the support amount that you're paying? So there are different circumstances that needs to be brought before a judge's attention, and then the judge can issue a refraining order, refraining FRO. But at the same time, the judge can also say, okay, we understand that you have been, behind in payment. So what would be an amount that you can afford to pay on top of what you have paid? Because, you have to, at the end of the day, abide by a court order, which basically gave you an amount that you are supposed to pay. And again, if it is a situation where your income has gone down or something like that, maybe you can also bring a motion to change the support amount if your income does demand a material change in circumstances, a review of the situation. So there are various options, but we need to get into the details of your factual scenario, and then only we can guide you further.
And certainly, the bottom line is do not ignore such a warning letter. There is a timeline to make the application and respond and bring the refraining order motion. You should be consulting a lawyer to assist you with any negotiation with the Family Responsibility Office. They're not always easy to get a hold of, but sometimes there's got to be some formality in terms of engaging the Family Responsibility Office in this process of whether it's a motion to refrain or negotiate a schedule for payment to catch up with the arrears. Daniel?
The last question we've received is, my son has special needs. He just finished high school and turned 18. I thought now I could quit paying child support. My ex-wife just wrote a letter to me saying that I have to keep paying. I think he should get a job. She says that he should go into a special government program which pays minimum wage. Do I still have to pay?
Well, if I may answer that question, the idea of child support, I think that goes back to the very first topic that we discussed here, and that is who's eligible for a child support. The dependency is the key issue here. If a kid is dependent because of disability, even if he's past the age of 18, he may still be a dependent. On the other hand, the ability of that person to generate income and become self-sufficient, whether it is through government resources, or DSP, or even a minimum wage, that could be a situation where the person is no longer a dependent and is able to sustain himself uh, for the needs that he needs. So everything can be covered through those wages or whatever the resource that becomes available due to his disability. So it's a matter, it's really a specific a set of circumstances that has to be analyzed and reviewed very carefully to determine if the person is self-sufficient, is able to become self-sufficient, or the parents have to continue and support that person.
Syed, do you have anything to add?
Nope, I think Golan has covered it all.
Okay. Thank you guys for those questions. If you do have any more questions or concerns, a consultation can be arranged to evaluate your specific situation or circumstances. As you can see, the contact information is on the screen. You can send me an email, give us a phone call, or you can visit our website for more information. As mentioned earlier, this was a general information session. Nothing mentioned should be taken as legal advice. That concludes our session today. I want to thank Golan and thanks Syed, and thanks everyone for attending, and hope you're able to join us next time.
Thank you, Daniel. Thank you, Syed, and the people who did attend this webinar this afternoon. We're wishing you all well, and you may contact us if you need any more information.
Yep. Thank you, Daniel. Thank you, Golan, and thank you, everyone.